Welcome to another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences. Dr. Steve Wood. If you have listened to the podcast with any regularity, you know that Bill and I are huge sports fans. We talk a lot on the podcast about sports, pro, but a lot about college sports. I'm a big Bleed Green Michigan State fan. So anything about Michigan State, I love to talk about. And one of the reasons why I've always been such a big college sports fan is because I've always been a big fan of kind of the grind, the grit, the determination of those college athletes, because they're trying to break in at the next level. So they're playing at a level that you don't necessarily always see out of NFL players. I've also been a big proponent of college players making money. Their universities are always making a lot of money off of their performance. So I always felt that it was fair that maybe some of these athletes should make money too. And a few years ago, they tried to put in an agreement in place to make that real. A lot of people probably know about NIL, or the name, image, and likeness deals that came into place. And that's led to some good, that's led to some bad in the college landscape. And it's also led to a lot of litigation. And that's what I want to talk about today. I want to talk about the overview of what NIL is, and then dive into more about the legal matters of it. And to help me with that, I brought on Jonathan Wohlwend. Jonathan is an associate attorney at Bradley's Birmingham office. Jonathan, how are you? Thanks for joining the podcast.
Good. How are you?
Great. Can't wait to talk to you about this. We were talking offline. You are a Tennessee, even though you're in the Birmingham office, you are a Tennessee Vols fan, right?
Yeah, so I'm behind enemy lines here.
Yeah.
Hoping for a good year. So
yeah, I mean, like I said, so far football team looks good, baseball team looks good. And as we talked before, nobody cares about baseball. I care about baseball, but down there, I mean, I'm in the South too. It's football, right?
yeah, it's all football down here. And now I still do brag about the national championship in baseball, but it doesn't have the same impact as bragging about a football national championship.
Yeah.
And when I moved to Birmingham, Alabama, like right after I got here, a few years later, they hired Saban. And that was a rough time to be a Tennessee fan in Birmingham, Alabama. I think they won 6 national titles. So
I'm still bitter about Nick Saban when he was at Michigan State and then left to go to LSU. So I don't think I'm ever going to truly get over that.
Yeah.
But and I appreciate you coming on. I know you do a lot of like trademarks, copyrights, and patents work, but I know one of your area of expertise, and in fact, how I reached out to you is I saw that you were doing a CLE on the topic of NIL. So that's really what I want to talk to you about today. And like I said, I'm going to kick it over to you to just kind of give us an overview of what is NIL and then what is it not, because even I am not even 100% sure on what exactly NIL is, and what can they do, what can't they do, and is it pay for play, is it not pay for play?
Yeah, so NIL, name, image, and likeness, is really born out of the legal concept of a right of publicity, which is inherent in every person to protect the use of their name, image, and likeness in commercial purposes. So name, image, and likeness, the term NIL now has encompasses the right of publicity, which is not a federal right. It's born out of state laws. So there's 33 states with explicit rights of publicity in name, image, and likeness, and then other states have sort of adopted not necessarily codified rules, but just follow those same similar common law right of publicity rules. And when people think of right of publicity, you normally think of a celebrity. It doesn't just apply to celebrities. It's more public based on celebrities because of the damages, really, is what that impacts, is how much money you can get for the misuse of your name, image, and likeness. But everybody has this right to protect the use of their own name, image, and likeness, to either prevent people from using it or to enter into deals to make money off of its use. And it's not by itself an intellectual property right. I think it falls under that category. It sometimes plays into the more common intellectual property rights like copyright and trademark. If you have an image of yourself that's copyrighted, then that's your name, image, likeness, and a copyright. Or if you use it as a trademark, then those can kind of intertwine and fall under federal law. But typically, you're going to be dealing with state laws or common law issues when you're dealing with name, image, and likeness. And you asked what it is not. And so name, image, and likeness is not new. It's been around for a while. It's new to the college world in that they're now allowed to profit off of it. It is technically not pay for play. It's not what it's supposed to be. This is a right for a college athlete who becomes famous to be able to profit off of advertisements or promotions using their name, image, and likeness. It's not it does not fall under the pay for play. That would be a separate issue. You're kind of seeing it intertwined nowadays in college sports because of the structure of college athletics with the recruiting and how you get players to come to your school. A lot of times they're going to want to come unless you can offer some sort of NIL deal or compensation. That's just the nature of the business, because it's competitive and everybody wants to one up each other. It used to be before NIL was, if we have the best facilities, we can attract players. Some of those funds are being now shifted to collectives to do these NIL deals to attract more players. So that's sort of where it's at now. Is it's not pay for play technically, but some people would argue that it's being used as a form of pay for play, even though that wasn't the spirit of what was behind the initial rule changes.
So if you can walk me back, like what would it look like? So if a recruiter goes to someone's house and talks about getting them to come, like what is the NIL deal that they're getting to get somebody to come to university? What would that kind of look like?
So they can vary. And really before that, the NCAA had rules which have been enjoined by the Tennessee and Virginia versus NCAA case, where you couldn't use NIL as an inducement to recruiting. The NCAA started investigating the University of Tennessee over potential allegations that they were using NIL for inducement. They then sued the NCAA and got an injunction saying that you can't enforce this rule limiting or prohibiting inducement as NIL. So they can technically do that now. So really from the beginning, they weren't supposed to be offering recruits NIL deals, but it was sort of impractical in how you would approach this recruiting cycle, knowing that you can induce them now, but once they get there, they can have NIL deals. So it's kind of this weird, like, how do you talk about the potential for NIL deals without also it being sort of an inducement for NIL? And those deals can vary. They can be small amounts, local companies offering small amounts of money to do paid advertisements, to do appearances, or it can be these collectives where they will have pots of money that they will deal out for autograph signings, appearances, saying we'll pay you this much if you do this many autograph signings or make this many appearances, then you'll get this amount of money. And that can increase based on how many appearances you do, how many autograph signings you do, stuff like that. And some of them are legitimate big time deals that you see in the news, where you see like players signing with Nike or big companies. You have some of those NIL deals as well. Those are rare. Those are not the common NIL deals, but you do see those with some of the bigger players.
You know, you'd mentioned like small companies doing autographs or doing different commercials and stuff. You know, I'm in College Station and I'm kind of out and about, but I haven't really seen a lot of commercials. I haven't seen a lot of things. I mean, where you're at, are you seeing a lot of these players doing these types of things?
Not here in Birmingham as much, but with Knoxville, Tennessee, you'll see some advertisements, some local companies using football or basketball players. There's one wide receiver for the University of Tennessee who has a deal with a cookie company, and every time he scores a touchdown, they offer free cookies to customers who come in the next day and say, so-and-so scored a touchdown, so I want my free cookie. You'll see some of those, and then you'll see some billboards around town with players on them occasionally advertising various businesses. Even some law firms have had some football players. I think one plaintiff's firm in Kentucky had an offensive line, the entire offensive line in an NIL deal for a billboard saying something about like defend. I can't remember what the slogan was, but it was something. It was a clever slogan using the offensive line for a team, and then something about their legal services. That was so you'll see some of those, but the ones you mostly hear about are the bigger deals, or the stuff that you don't see is like these autograph signings can usually be for a select group of donors to the collective that will go in and get signed autographs, and that player gets paid for doing that. That's also what you'll see.
Gotcha. And you've mentioned collective multiple times. I want to talk about that. What exactly is a collective? And I know that people get asked to donate to the collective. I know Bill, my colleague, has mentioned before he gets reached out to by UNC to donate to the collective. What is that? What is that process? And where's all that money coming from, and where is it going?
So the collectives are technically third-party entities that have been formed to sort of collect, not to use the word in it, but collect money to negotiate and do NIL deals with players. And the way they raise funds is through donations. So a lot of the bigger schools are getting the big time school donors to instead of, maybe not instead of, but in addition to donating to the actual school, to donate some money to the collectives. And then they will take that money and do NIL deals with players. Whether or not your donation is from a company or an individual will sort of shape how that deal works out. And in the beginning, you really didn't get a whole lot of benefit from donating to the collective personally. I mean, it was to help your school get better players, really. I mean, practically that's what it was. There were some that were trying to set up as 501c3s, but then the IRS sent a letter out saying like, hey, we're not so sure that this qualifies as a 501c3. So they kind of shifted away from that. And now with some of the NIL rule changes and NCAA getting into some legal trouble, collectives have started, they're now allowed to work closer with the actual universities. At first, they had to be totally separate. They couldn't really interact or work with each other. Now the schools are allowed to facilitate deals for players, including with the collective. So now a lot of the collectives are giving priority points for donations. So better seating, access to certain things that you wouldn't get access to unless you were a donor to the university, to the collective. So you are seeing a lot of schools and collectives kind of work hand in hand more to promote donating to the collective for NIL deals by offering university benefits like better seating, box seating, stuff like that. That's technically against the NCAA rules, but nobody's really stopped that from happening, and I can't envision the NCAA stepping in and doing anything about it at this stage, just based on the amount of litigation they're facing. Every time they do something, they get sued. So they're kind of stuck.
I want to talk about litigation in a second, but one of the issues I can see is now you have these athletes who are making $1 million, $2 million from their NIL deals. Now it seems like there's this expectation. Well, if you're gonna make $1 million or $2 million, I expect you to perform at the $1 or $2 million performance level. Have you heard? Is there any sort of ramifications where you see on the horizon where people are going to start doing anything as it relates to basically not living up to the hype, not living up to the contract of sorts, right? We see all the time on pros, you're paying Deshaun Watson, you're paying these other people. And as soon as they don't perform at that level, they're getting a lot of pushback and a lot of hatred on social media because now you're getting paid and we expect this out of you.
Yeah, I mean, I think that you will get a lot of pushback. Whether or not you can enforce that under the contract is not within the rules. So technically, it can't be, the NIL deal can't be based on It can't be paid for play, so it can't be based on athletic performance. But a lot of them are structured in a way to where if you so autograph signings, for instance, if you go out and you underperform, you probably won't get as many people wanting your autograph. So that'll lower the amount that you'll make on your NIL deal. So they're a lot of these are sophisticated entities that are doing this, and they've kind of figured out ways to structure it to where you can fit it within the rules. That's not based on athletic performance technically, but sort of also is impacted by your athletic performance, if that makes sense.
Yeah, there's a lot of gray areas, which I mean, that's why I want to talk now and kind of spin is, can you talk a little bit about the litigation that there has been, both kind of the initial litigation, the NCAA v. Alston case, essentially where everybody thinks that's kind of a start of NIL, but I'm not sure, based upon my understanding, that's not exactly where it started in a true sense. I mean, then if you can walk forward about what have been kind of the key litigation that's occurred since that, kind of moving forward, and what's the current landscape look like?
Yeah, so the Alston case is the one that everybody talks about as being the catalyst that started this whole NIL movement. And it did in a way, but the Alston case was not about NIL. It was about education-related benefits and restrictions on that under NCAA rules. The reason the Alston case was important is there's two reasons. One was the Supreme Court kind of rejected this NCAA amateurism theory and sort of this idea that they should be subject to a different standard under antitrust review. So in Alston, they looked at the NCAA's education related benefits using the rule of reason standard, which they found that they couldn't limit, that their limitations on education related benefits did violate antitrust. So that was sort of where that all started. Even though it's not NIL, it was a time when the NCAA rules were looked under the rule of reason for antitrust, which kind of had people thinking like, oh, well, if that's the case, then a lot of these other rules that they have might not survive antitrust review. And then there was the Kavanaugh concurring opinion that gets cited a lot, where he basically said in it, we're saying this violates antitrust, and I'm not so sure that your other rules wouldn't also violate antitrust. Now, he was the only one who wrote that opinion. Nobody else was concurring with him, but it did kind of set the tone of, okay, we're going to start looking at these rules a little differently than we have in the past. So we're going to start applying the rule of reason under antitrust. And so that calls into question some of your other rules. And the reason Alston was also big is because at the same time, well, before the Alston decision, California had passed a state NIL law that would allow college players to earn money from their NIL, but that didn't start till 2023. And then once other states saw that happening, Florida became a state that said, oh, well, we'll do that same thing, except ours will start in 2021. Then once Florida did that, of course, it's the SEC. So every other state in that conference was like, well, we can't let the Gators beat us. So we have to do the same thing. So other states started passing laws that also would have changed the rules in 2021. And then the Alston decision came out in July of 2021. So it sort of started this thing. The NCAA was sort of waiting on that decision. That decision came out saying, oh, we're reviewing it under the rule of reason. And Florida had this law. So then after the Alston decision, the NCAA issued the NIL interim policy, which basically just said, we're not going to enforce the prohibitions on NIL that we previously had. And that's sort of how the snowball started from that point. And to get into sort of other cases, the big time other cases that happened right around, I think it was 2021, right around the same time, there was a case, an antitrust case filed called the House versus NCAA case, which is the big one. There are several others, but the House case is the biggest one. that was an NIL, saying that the rules on NIL were an antitrust violation, and that college athletes going back to 2016 are owed back damages for not being able to earn money off their name, image, and likeness, and that current college athletes also should be awarded damages and a change in the system for how they are allowed to earn money off their NIL. So House sort of the damages, I think potential damages in the House case were, I want to say like $4 billion, a lot of money. So that kind of raised the pressure on the NCAA. And then you had multiple other cases. You had the Hubbard versus NCAA case, the Carter versus NCAA case, which are also NIL related antitrust lawsuits that have been consolidated with the House case. So you have those three cases. Then you have another NIL antitrust case, Fontenot, which was filed in Colorado, going on at the same time. And so the NCAA was facing billions of dollars in damages. And so the current landscape of the House case was there was a proposed settlement, which I'm sure some people have heard about, that was entered in May of 2024 of this year, where they are saying, okay, we're going to change the NIL rules. We're going to pay back damages, 1.8 billion, I think, or something like that. It was 1 point something billion. I can't remember the exact amount, but it's a lot of money. And then we're also going to allow schools to pay student athletes for NIL for up to $20 million a year. We're going to allow third parties to do NIL deals, but we're also going to have this review system where we're going to review it to make sure it's a legitimate NIL deal. And so that got filed. The proposed settlement got filed, and they had a hearing on September, I believe that was like the 4th or the 5th. And a lot of people were expecting the judge to grant preliminary approval. She did not. So Judge Wilkin in California did not grant preliminary approval. She had some issues with the way the settlement was structured, specifically regarding this. One of them was the pay for play issue. So technically under settlement, pay for play would still be prohibited. And she was wondering how that would work when you're allowing schools and third parties to pay the players for their NIL, for legitimate NIL things. And she's like, how are you going to differentiate between that and pay for play? That seems like something that's going to be challenging and maybe not practical. And she also had issues with the settlement lasted for 10, it's a 10-year run. So she was like, well, what if you have a student athlete who's in high school right now, and then he goes to college, and then he's subject to these rules and this settlement that he wasn't involved with at all during it. So we're waiting to see if they have a hearing in 3 weeks to see if they can work those issues out. But it's up in the air right now with the House settlement.
Yeah, there's a ton of litigation around this. I think I saw something this morning. They were talking about Michigan was going to sue the Big Ten network for some money that they were owed to. Like it was Denard Robinson was trying to sue. So you have a lot of those too, right? A lot of additional players coming out of the woodwork now to say like, hey, wait a second. I need to get, where's my money at?
Yeah. So the House settlement covered players that played from 2016 onward. Now you have other lawsuits. The Denard Robinson lawsuit, for example, he filed that yesterday, I think, where he's saying, I played before 2016 and you guys exploited my name, image, and likeness, and you had these rules prohibiting me from earning money. And so I'm owed money for that as well. That lawsuit, I think, is for $50 million. So, and you have another one involving a former basketball player suing the NCAA for use of his name, image, and likeness in the One Shining Moment video, where he has a moment in there that gets replayed every year, and he's like, well, you guys never paid me for that, and now you're changing the rules, and I should have been allowed to make money off of that. So they're facing uphill battles everywhere they
Yeah.
look.
And I
So
think you're going to have a lot. I mean, it'll be kind of a litmus test of sorts. Let's say, for example, Denard Robinson wins, then it's kind of a snowball effect. Where does it start and where does it stop? Now, is each player going to start reaching out and doing it? Our team's going to do it. I think it's going to be interesting to see how all this kind of rolls out. I mean, I think that from a legal perspective, is there a way to even insulate yourself from that, where there's any sort of things you can put in to say, okay, we can't go back any further than this amount, or we're going to limit it to this amount of money? Like, what's the legal landscape look like, or is there anything?
yeah, I'm not sure there is anything. I mean, I think that's one of the issues that they're facing is that we're trying to change these NCAA rules through litigation and settlement, which is probably not the way to do it. I mean, I think if you're going to do it, you might need to do it through the NCAA system, or a lot of people are arguing for collective bargaining to let the players unionize. So that way that alleviates a lot of the antitrust concerns with future rules. But you still have this past rules to deal with. And the question is, how far back can you go? Can you keep going eternity? I mean, nobody really knows, and I think that's the struggle that the NCAA and the schools are facing is like, when does it end? When can we say, okay, we fixed it, everybody's happy now? I'm not sure that we know the answer to that. Right.
Yeah. And I want to move on from NIL and talk to you a little bit about you. Before you actually came there, you were an assistant JAG officer in the Air Force, were you not?
I was, yeah.
Yeah. So can you talk to me a little bit about that? Like, how is being a JAG officer, and then now where you're at in your position? Like, what skills set did you bring from that has transferred over to your current role?
So yeah, it was definitely a different role as a judge advocate in the Air Force. Mostly did criminal litigation, so handled prosecution of crimes in the Air Force. So a lot of that doesn't necessarily translate to NIL stuff. I mean, I think the litigation is helpful in that I was in a courtroom basically every day that I worked in the Air Force. So it was the courtroom was literally not right next to my office. So I would just go in there every day and we'd have trials or hearings or something. But I think the biggest skill that translated was time management and management of people. That was something that you had to learn pretty quick in the Air Force. You're dealing with, you get there, you go to training, and then you get sent to a base, and you're you're the guy you're put into the fire. So you had to learn how to manage both your team and the tasks that you had. So it's more of a leadership and management skills that apply rather than the actual legal work that I did, because that was mostly in the Uniform Code of Military Justice, which doesn't come up very much in IP or NIL, but some of those real life experiences of just talking in front of people, managing people, dealing with multiple tasks at once have definitely helped in that area for sure.
A lot of our listeners are probably more mid-level, associate attorneys working their way up, or new partners. I mean, as far as that goes, what kind of words of wisdom do you have for them as far as what you've seen from your position as a JAG officer now here, like as far as to help them increase and get better and move along in their career?
Yeah, I mean, I think, maybe this is quote unquote coach speak, but you take it one day at a time. When I came into private practice, it was definitely a shift. I mean, there was, I'm now working on billable hours, which is a different structure than I was used to. But if you just keep focused and you have a task in front of you and you focus on completing that task and just take it one day at a time, I think that you'll see some success born out of that. And as far as, if you want to break into an area or a field and like NIL, really how that happened with me was I just happened to be at the right place at the right time. I'm in Birmingham, Alabama. We're pretty big into college sports down here. We don't have professional sports teams, so that's sort of our outlet. And I saw the rules were about to change, and thought, oh, this could be big. I mean, there's going to be tons of money. It's $1 billion industry. There's lots of opportunity there. And so I just started writing on it, reaching out to people in the industry, going to conferences, doing things like that, just meeting people and sort of talking about the subject. And that's a great way to sort of take the initiative and get your name out there, even if you don't have much experience in it. And NIL was kind of lucky because nobody had experience in it that didn't exist before. So we were all sort of on an even playing field. So that sort of helps there. But if there's something that you want to do as a young associate or a new partner, and you see an opportunity, I would encourage anybody to just start writing on it, start getting the word out there, start going to conferences, start doing things that can help you to build sort of your knowledge base in that area.
Yeah, I think that's great because, when I talk with other attorneys and even older attorneys and say, how did you get to where you're at? A lot of times they said, I asked to do things. A partner came to me and says, I need someone to do something. And you're the first person to say, me, I'll do it, just to try to get more experience.
Yeah. You never know what it can lead to, right? You never know what that one project or that one case might lead to in the future. And so even if it sounds like something you're not interested in at the time, maybe do it and put your best effort into it. And if afterwards you're like, that was terrible, that's fine. But if afterwards you might like it, and then it grows into something bigger, right?
Yeah. And Jonathan, in addition to NIL, what can you talk about? What other types of cases are you working on?
So I do a lot of just base intellectual property stuff, trademark applications, trademark enforcement, writing cease and desist letters, copyright protection, patent drafting. I'm patent barred. So I do a little bit of that. My background's in biology, so I know I have a weird background, but so I do biology stuff, and then I also have an area of practice in government affairs where I do sort of legislative review, legislative drafting. So I don't actually lobby, but we do have a lobbying effort that we do here. So sort of that, and that's sort of what shifted me towards NIL, was that there's a lot of NIL legislation going on as well. So, and it's intellectual property. So those kind of combined and sort of met at the same time. So that sort of worked out. But yeah, so my practice is all over the place. I do some intellectual property litigation as well. So a mixed bag of work there.
Biology to intellectual property to trademarks. How the hell did you get to that?
I was in college, didn't know what I wanted to do. I changed majors like 3 times. So I think I went I know exactly what my majors were. I started out as graphic design. Turns out I can't draw. Then went to international relations and was like, I don't even know what this is, but it sounded cool. And then I was like, no, this is not going to work. So I eventually landed on biology, and then after graduating college in 2009, not a great time to graduate college. The economy was not booming at that point. Took 2 years working in a biotech lab, and then was like, I think I want to do something else. So I did law school, and then it all just kind of happened from there. Sort of that's just the way it went. Just went with the flow a little bit.
Yeah, very cool. Now you get to work on a very cool topic. Like I said, I appreciate you coming on because, as I said, as a college sports fan watching NIL, I had a sense of what it was, but after talking with you, I realized I don't really know much of anything about NIL. So I appreciate you coming on. If anybody wants to get a hold of you, if they want to reach out more to you and talk to you potentially about working on cases, or just talk to you about NIL litigation or learn more about NIL, how can they reach you?
Yeah, so you can just reach out to me at jwohlwend at bradley.com, or you can just give me a call at sorry, I've got to look, 205. It's 205-521-8349. That's it. 205-521-8349.
Well, I appreciate it, Jonathan. We'll probably have you on later as these litigation keeps rolling out, I'm sure I want to be checking in with you and probably have you on a future podcast to talk to us more about what's going on in the college sports and in NIL. So appreciate you.
Sounds great. Hopefully, I'll be wearing my national championship shirt if we come on after the season ends. We'll see.
Go.
Yeah.
Be hanging the big Tennessee flag. Just be completely all orange.
It'll be a banner back here. It'll take up the whole space. Yeah.
There you go. All right. So as always, I appreciate the listeners. Thanks for tuning in. Greatly appreciate everybody who comes on and listens to it. This is kind of the main reason why we do it, is because we love to be able to give out information to listeners. Appreciate all the feedback that I get. Keep it coming on that. As always, go to courtroomsciences.com. All the other blogs, podcasts, papers, all of that is up there. Join us for another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences.